Broadcast is now starting. All attendees are.
I think we're going off our script, so.
Yeah.
Good morning, everyone, and welcome to the class of the year that you all have been waiting for, your 2018 Forms Changes. This is Jenny Pakula with OAR, and we are fortunate enough to have two very experienced principal brokers here to educate you on the changes and how to implement them. We have Steve Russell with us today. Steve has been in real estate with Windermere Realty Trust since 1996. 3 years later, he became the assistant branch manager at the Lake Oswego branch. During that time, he worked to receive his GRI and was on the first Windermere Foundation Committee in Portland. Steve received his integrity coaching certification and was the CB SEAL agent coach until 2011 when he became the Moreland branch manager at Windermere. Steve was also the 2017 OREF Forms Committee chair. With Steve is Marie Dew. Marie is a principal broker at RE/MAX Integrity and is a dedicated, proven professional in this field, challenging field, i.e. supervising brokers. Marie brings more than 35 years of sales and marketing experience, including photocopiers, Pepsi Cola, barcode scanners, and slot machines. That'll be at our next OAR event. We're going to have slot machines. She's been a realtor since 2002, and her diverse abilities reflect a natural gift with people and the high demands of a service profession. She's the 2018 Forms Committee Vice Chair and has been on the Forms Committee since 2014. So you can see we have very experienced folks with us here today. You all know the drill. Please send over your questions, and if time permits, we certainly will get to them during the presentation. If not, we will do our best to save them and answer them after. We have a lot of material to cover in an hour and a half. Steve and Marie, take it away.
All right. Thank you, Jenny. First off, welcome. You will be seeing on the screen the same thing as the printout. If you don't have the printout and you're just looking at the screen, whatever the case may be, they're both exactly the same as they're going through here. A couple of things. One, in order to put this together and have it in time for all of these were beta. So a couple times you might see a misspelled word here, or you might see some initial boxes stuck up in a weird place. That's not how the forms look. That was just when we're putting the whole thing together. We'll mainly be working off of the yellow highlights. So hopefully if you did print it out, you print it out in yellow, or at least you can see where it's highlighted. But I will say that when put it together, there's a couple of forms we put everything in, even though there wasn't a change on every page because we felt that it was critical. So the residential sales agreement, Jenny's having fun with it.
Sorry, multicoloring. Excuse me, a little tech challenge.
Okay, so the residential sale agreement, I believe the contingent right. There's a couple of forms where we have all the pages for your resources, but we're really just going to be covering what's in yellow, except for this very first one. Well, wait, I'm going to have Marie talk about a change that's going to be happening maybe tomorrow.
Many of you probably have heard that the legislator did a change January 1st having to do with questions on the seller's property disclosure. And we were OREF was just given the changes here in the last week. And by Friday, the update to the seller's property disclosure will be on zip forms. So you'll be able to use the new one, the new version that will have the proper wording in it. And so look for it on Friday. In some cases, you may be needing to ask your managing broker if you need to update any listings that you have, if we already have that information, because it is having to do with seismic issues. It says, was the house constructed before 1974? And if yes, has the house been bolted to its foundation? Questions that we all need to know about.
Absolutely. And the other change is with if you're concerned, you're used to it being 5 pages and now it's 7 pages long. That's not because there's 2 more pages of content. We just made the font a little bit bigger so you could see it a little bit better. But there's no changes in that. And so anyway, that's going to be coming hopefully tomorrow is what we're hoping on the change on this.
Friday.
Mm-hmm. I'm trying to race the week along. Okay, originally I'd said that everything's in yellow. The first thing I'm going to say here is not in yellow because otherwise we'd have been putting yellow everywhere. The definitions state that delivery to the agent is the same as delivery to the client. But throughout all these forms, it would say buyer and buyer's agent, seller or seller's agent. It slowed down the process when you're looking at it, and it wasn't necessary. So you'll be seeing delivery to buyer, delivery to seller, just for convenience. However, that doesn't mean the buyer's agent walks over and hands something to the seller or vice versa. Nothing has changed in the law. You're still working agent to agent. It's just we did that to make it a little bit cleaner. Okay.
First yellow.
First yellow.
All right, here we are.
One of the changes that we did was we added the words fixtures, controls, and keys. That's because besides just having keys and the garage remote, we now have ceiling fan remotes. We've got window covering remotes. We've got all of those things. So we've now added in all fixtures and essentially related equipment needs to be provided and stay with the house.
All right. Financing, this is a situation where it puts it into everybody's consciousness, really, when you're working with a VA loan. As you know, most VA loans, federal VA loans, will have buyer non-allowable closing costs. And this was always, a seller could get surprised at closing and they're having to pay an extra $1,200 they weren't expecting to pay, and it made them cranky. This just brings it to the forefront. So just putting it in there and staying in contact with your lender and finding out whether the seller is needing to pay that or the lender's paying for it, whatever the case may be. So it's just a tickler for everybody to know about those VA loans.
And one thing that'll be helpful on that is talk to the listing agent beforehand. I know that's shocking, but talk to the listing agent beforehand and find out what the seller's thoughts are. That would help on the form to do that. One other financing item that we added was the now under Section 8, line 143, we added the words closing costs. We had a lot of discussion in Forms Committee about this because we didn't want to just have a buyer go, oh, wait a minute, we can have the seller add it. But in order to make it very clear to everybody that uses the form, whether it's the sellers and the listing agent or even the mortgage folks, having it in the same place at the same time is very helpful. So this is the area where we really want you to put, if there's buyers, sellers, closing costs, please put it in there.
Absolutely. People are putting it all over the place, so that's going to be good. This is just a subtle change. It used to say invasive inspections that may include testing or removal of the portion of the property, including radon and mold. The words, for example, were not there. Turned out that somebody felt like they didn't need to put those in and they had the right to do a radon and mold test just because those words were there. That was incorrect. However, just to avoid controversy, now it says, for example. So if you do want, or the buyer does want a radon or a mold, you do need to put that down on the invasive inspections line. Oh, I'm doing the next one? Okay, lead-based paint. All right, lead-based paint. There's two parts to this one here. And if possible, could we close the box out just for a second?
Right here, Jake.
I don't see all the text at this point. There we go. Yeah. All right. There's two parts to this. One is the case of, there's three places where it says the amount of days on the lead-based paint contingency period. There's the place that's on the sale agreement, and then there was two on the lead-based paint addendum itself. Turns out that all three said something slightly different. So in order to make it consistent, we changed it, and the only place that you actually put how many days it is on the sale agreement, not on the addendum. So unless waived by buyer in writing, the disclosure addendum, buyer shall have blank calendar days 10 or other mutually agreed upon period commencing on the day following the date of delivery. So this is a date of delivery situation. It's not mutual agreement. And also, they read through it, and it could potentially be less than 10 days if they mutually agree to it. But really, if the buyer wants 10, I'd give them 10. If it's a federal law, I wouldn't be messing around with it. But that's a negotiable item right there. So that's the first part. The second part is people were feeling that this clause, being a federal, which has a bunch of clout with treble damages, et cetera, and things like that, we're using this as an out. Oh, I'm just going to get out based upon the lead-based paint. I personally haven't seen it done much, but apparently that was a big concern. So there's something I want to point out in here. I'll just read it. If lead-based paint and or lead-based paint hazards are identified in the property by a certified inspector, so it has to be actually have it, right? So they can't say I'm getting out if there's not. At any time before expiration of the lead-based paint contingency period, buyer may unconditionally cancel this transaction by writing to seller. Okay, This is the part. In such case, buyer shall deliver a copy of any written reports or evaluations to seller together with a notice of cancellation. So this one is different than all the other inspections where you have to ask permission. The seller has to request any reports. This is a case where no, the buyer has to give it in order to get the right to for cancellation.
One of the things that we've been doing with the forms this year is we're trying to make them a little bit easier for us to find, because whenever I had to fill out the septic form, I always knew that I had to go look under O's for on-site sewage. No, wait a minute, it should be septic, it should be under the S's. So now that form is just had a name change, nothing else has changed. It's under the S's for septic or on-site sewage system. You'll see this a few other places that we've tried to make it easier in the actual way that we use the forms.
I love it.
Mm-hmm.
Okay, FERPTA. We're not going to talk much about FERPTA right here, okay? We're going to talk about it more at the end when I'll be hoarse and have to cut it off quick. No, but this just clarifies again, and a reminder here that there's an additional withholding responsibility. If it's 300,000 but less than $1 million, it's 10% that has to be withheld in the case of FERPTA applying, right? Only if that's applying. Or if it's over $1 million, it's 15%. So that's all I'm going to say about this right now, and then we'll talk about it later when we get down to the advisory and to the actual addendum.
Next item is that in section 17, it was the townhome plan community. We've added the word homeowners association, HOA. We really need to see this document used because of the fact if you've got a homeowners association, use this document. It has all the information you need on it, for everything from who the management company is to the information. In fact, this may be one of the forms we changed this year to call it HOA. But one thing is that if you've got a condo, use the condo form. But if it's an HOA, whether it's a townhome or any sort of a development, use the form.
Absolutely.
It's there for you.
It really is. That's okay. Alarm system, just a little note here. This is one of those lines where sometimes you don't know about the alarm system. A lot of times you don't know about the alarm system, and hopefully you can get that figured out with the listing agent before you write the offer, but sometimes that's just not possible. So instead of leaving the line blank, which means either you didn't know or you forgot, there's now actually a box that says unknown on here. Now, if you do mark the unknown box, your job is not done. You'll need to go back and make it known to the buyer later on, but you can get to mutual agreement without a blank line. So it's good, but just, if unknown's there, clear that up later on in the transaction.
Now that's just a practice tip, right? There's nothing in the I mean, it's a good practice tip, but I just want to make sure there's nothing in the sale agreement that would make it contingent or some other thing if they don't get the information.
Oh, absolutely.
Yeah.
I jump into managing principal broker mode sometimes, so I'll be jumping out. But fortunately,
that's why you're here, Steve.
Fortunately, legal counsel is here to keep me straight. Okay, Marie just passed this back over to me, and darn it.
You get the next two sections here.
I get the next two sections. Okay, actually, I really like this change. I'm going to read this through because it seems like I've had several people miss lines 306 and 307, and they're important to when you're looking at this. So, when the sale agreement is signed and accepted by buyer and seller, the following instructions shall immediately apply to the handling of buyer's earnest money deposit. So people are saying, well, when does it start? When does the clock tick? Well, it states that right on 306 and 307, so just take note of that. The deposit shall be payable by electronic funds transfer or check drawn on collected funds. And what we mean by check drawn on collected funds is just kind of telling the buyer you have to have money in the bank. So we're still accepting we're still saying a personal check is fine. They don't need to go get a cashier's check. There has been some confusion on that. It's okay to have a personal check, but it's just, hey, have the funds in the bank. So the collected funds and deposited within 3 business days as follows. And then there's directly with escrow, and then 2 different options with the buyer's agent firm's client's trust account. Something you'll notice, and I'm sure everybody's been having conversations about it, there is no promissory note. So Jenny was here and she did some great research on this. I'm just going to steal a line I think that she already said just earlier. And this is, we went out to the other states. It started off with the promissory note being a situation where it was problematic with the real estate agency and the way they want you to handle a promissory note and electronic signatures. what's an original electronic signature? I mean, you can make a million of them, right? So then we went out and we were looking at other states, and what you found is they don't even know why we have a promissory note involved. Is that correct, Jenny?
Yeah, absolutely.
So we went, wait a minute. So it expanded beyond trying to clarify that to why do we have this? And so it is out at this particular time, or it's just out. There's no promissory note. Now, when you're handling this, I'm just going to talk about what Jeff Wyron, who was the chair 2 years ago and is still very much involved and a great agent manager. You'll notice that there's no place for the agent to sign receipt here anymore. So when you're writing an offer, you don't get a check from them. There's no promissory note, not a check. This is what you're going to be dealing with. Once it's mutually agreed to, then it's the buyer's responsibility to get the money to title or to the buyer's agent firm's client trust account. And he's advising his clients, don't be a conduit. If you want to be a conduit, that's your call, and talk to your managing principal broker. But really the intent is, especially with the 3 business day situation, and not that it used to be soft with the redemption period and how long you could hold the check. Nope, it's 3 business days. So think about that. If you have an out-of-town person, maybe you need to make that 5, or maybe make that 6. This is just an automatic, just leaving it blank. Think about that because it's very important. Because down on lines 314 through 316, the deposit payable by whatever method selected by a buyer above shall be placed with escrow or buyer's agent firm's client trust account no later than 5 p.m. on the last day of the deposit deadline. The failure to do so may result in a breach of the sales agreement under earnest money payment refund section below. Even though it's like 2 paragraphs down, we're going to do there in a minute, I like it's right there. And that's just a help for you as a buyer's agent saying, okay, you need collected funds, do you have money in your account, and we have to make sure that you have the ability to put there in that amount of time.
Steve, could I just make one comment on the promissory note? Only because I'm guessing some of our listeners may be saying, okay, we don't have it, and other states didn't do it, but that doesn't really tell me why do we have it in the first place and why do we not need it. As you all know, the promissory note, that was just one extra piece of paper you had to deal with, one more task for you to follow up on and make sure it's properly redeemed and return the original. And as Steve was mentioning, all of the electronic DocuSign stuff you all do, it makes it much more problematic. But the reality is you didn't need it. It has the same effect on the contract and whether the buyer's in breach. What if the buyer didn't redeem the promissory note? Breach, right? The seller would have to pursue litigation if they wanted to. The same language is simplified and contained within your contract on line 308 and 309. I mean, you're within 3 business days, you're collecting a check and depositing. It's the exact same effect as a promissory note. If the buyer doesn't do it, they're in breach of the contract. Seller has to pursue litigation if they choose to. So you're gaining something with no promissory note, not losing something. Less risk and more ease for you and your clients. All right, carry on.
Very good.
The next section of 24.2 about additional deposit, that is linked to section, or the very first page where you had additional earnest money and how you're going to handle it. So you put the number on that line and then figure out that right here in section 24.2 lines 317, 318 is where you can actually say how it's going to be handled, when it's going to be done, where it's going to be done, and who's going to be doing it. And it follows through with all the rest of the items that we had.
Cool. Okay, this next section, there's a change at the end, but the rest of it is the same. It started off as a change just because we needed to take any reference to a promissory note out of it. But while that was going on, they split it, and I think Monica must have done that because I don't remember talking about it, but split it into 2 sections instead of 1 section, which I love because it was a bunch of legalese in a row, and you couldn't figure out when does the seller start, when does the buyer start. So it's in 2 different sections, which I think is going to be very helpful for reading through that. And I'm not going to go through the points on this. On the earnest money payment seller, there's a section here I want to talk about, and it's highlighted. The parties expressly agree that seller's economic and non-economic damages arising from buyer's failure to close his transactions in accordance with the terms of this agreement would be difficult or impossible to ascertain with any certainty, and that said earnest money deposits identified herein shall represent a binding liquidated sum, and that it is a fair, reasonable, and appropriate pre-estimate of seller's damages and is not a penalty. The situation and why this was changed, if you look back at the 2017 form and the ones before that, it talked, I believe, about a statute in there, and it was very benign. Every place else it says that the buyer, the earnest money is the money that it's at risk for the buyer. Well, it turns out that that Oregon statute could be read to say, if it gets into being in front of a judge, let's say, and I'll just use an extreme example. Let's say it was $100,000 earnest money on a $300,000 house, right? Silly, right? But I'm just going to use that as an example, and they just didn't get their collected funds in place, and the check bounced. And if you read the section, that's a place where the seller could say, okay, well, give me that money, and this is terminated, and I'm going to my next buyer. That money is mine. The old way, a judge could sit there and say, well, 6 days, you already have another buyer. That's ending up being a penalty for $100,000 for 6 days. The way it's written here now is, if that earnest money is out there, the full amount is at risk. So when you're working, just as a practice tip, I would have a conversation if somebody really wants to make their offer really sweet by putting a lot of earnest money down, which we see, to tell them, okay, remember, that money is all at risk.
Good tip, Steve. Big one.
The next section that we kind of made it a little clearer on the utilities. It now states the seller shall not terminate or disconnect the electric, gas, heating, fuel, includes propane, or water utilities prior to closing unless parties agree otherwise in writing. That way we don't have sellers, oh, hey, we're pending, the power goes out. And the words agreed otherwise in writing, that does cover those REOs where all the power is out and those things that the banks require you to go and have the power turned on to do inspections. That doesn't change anything, but it says seller, don't turn the power off or the water off or empty the propane tank or have it removed.
This is me?
Yeah.
Okay.
Yeah, this is
This is me again. Okay. Dispute resolution. Nothing has changed in the dispute resolution verbiage, but there's this first part that I want to talk about and why Phil was very firmly in favor of putting this language in. And if you look at his summary, he brings up 4 different cases. I mean, he's very thorough about why he did this, but he was very passionate about it. But I'll just tell you, all claims, controversies, and disputes between seller, buyer, agents, and or firms relating to the enforcement or interpretation of the sales agreement, including those for rescission, as well as those relating to the validity or scope of the sale agreement, and all matters concerning the jurisdiction of the arbitrators and or arbitration service of Portland to hear and decide questions of arbitrability, that's your new word, here and after collectively referred to as claims, shall be exclusively resolved in accordance with the procedure set forth herein, which shall survive closing or early termination of this transaction. Now I think, well, why did they put this language in? And I always felt like, well, okay, this dispute resolution, the buyer and the seller agree to this form of dispute resolution. And so if it's $10,000 or less, it's going to be small claims court. Over $10,000, it's going to be arbitration with also the mediation clause, whatever the case may be, that whole thing. Well, it turns out that in actual cases that were going forward, that a judge in a couple of cases was saying, this is something that needs to be litigated. And so even though the buyer and seller had agreed to dispute resolution, the judge was making the decision that no, you two parties are going to go a different route here, which infuriated Phil. And I agree because I didn't even think that was possible. But it did occur. So this language is hopefully making it stronger so the actual dispute resolution we all know and love actually works all the time.
This next section actually was your section. I'm going to have you talk about it because you're excited about having all of this change here in signatures.
Oh, you're really doing it. Jenny, please scroll up just a little bit.
That one?
Yeah, that's correct. Yeah, a little bit more.
Keep going up. Yep.
Okay, so so right here on lines, and it's not in yellow, but on 476, it talks about this offer shall automatically expire on. And then it had a deadline there, okay? And there was some other verbiage that was there. You'll notice it's not there anymore. And it was with the late acceptance. So as you remember, in the acknowledgement set, for years, they're trying to figure out what to do with a late acceptance situation. And in the middle of the acknowledgement section, we threw the late acceptance with the agrees or disagrees within 2 business days section. And then that was messy. So then we separated the acknowledgement section from the late acceptance section, and then we put the delivery information on it. And we tried to do that. Then people were confused. Do I sign both? Do I sign one? What do I do? Who do I do this with? It was missed. And then we had the situations where it was past the 2 days. And now what do you do? So, and as a managing principal broker, I would find that it would be 7 days later, I would see that, oh, we actually don't have an agreement. What are we going to do at this particular point? So there is no late acceptance section anymore, but we have this, okay, now we can scroll, Jenny. We have this verbiage. So if delivery transmission occurs after the offer deadline identified at offer purchase section above, it will not become binding upon seller and buyer unless the parties agree to extend such deadline by an addendum, counteroffer, or other writing jointly signed by the parties. The parties failure to do so shall be treated as rejection under seller's rejection section below, and this transaction shall be automatically terminated. I really like this because before we had this, well, if it's within the 2 business days, we had something in there, but it was after, you don't. It's just now it's going to be the same procedure. So getting back into more and talk to your managing principal broker, if you're accepting an offer at the time and you see, oh, it's late, so your seller wants to accept it, but it's already, it's late. At that time, I would most likely recommend a seller's counter offer, and maybe the only thing you're countering is, that you have as a counter and they accept it and it can go on. If the seller has actually signed this section saying they agree, and then it's found out later that it was late, you're going to need to use that addendum. And just another tip, I would recommend that you not only put, let's say it's 7 days later, so you're going to write, you're extending the deadline. So you're getting so it actually have agreement. I would also have a conversation between all parties when the actual timelines are to begin, because mutual agreement will be when that's delivered back to the other party, right? But maybe everybody's thinking, well, no, that was 7 days ago. Let's just start on that day. Just have a conversation and memorialize that in the agreement. And I would also put a deadline on there as far as, okay, I'm giving you this addendum, but you need to respond within a day or something like that and make this thing going. You want this thing floating out there for a month and a half or something. So those are the 3 things you're going to do. But I really love, it's consistent now, and there's no late acceptance section. You want to do the acknowledgement, or I'm not?
No, go ahead.
Okay.
This was you were so excited about this during the committee meeting. This was your section.
The acknowledgement is, yes, there's no acknowledgement anymore. And so I'm going to try to purge from my mind how to spell acknowledgement, because I've had to spell it so many times over the years. But anyway, there's no acknowledgement section, which had a nice byproduct. And I'll just zip through this next section because let's go through the next, or just keep going. Just keep going. Mm-hmm. So the only change in the buyer's counter offer is there's not any acknowledgement or late acceptance section, and the same thing on the seller's counter. But a byproduct of this, the seller's counter without those 2 sections is now only 1 page and not 2 pages. Yay! All right, Marie gets to talk now.
Vacant land sale agreement. We added some different wording to the vacant land sale agreement. Wait, get my tongue untied here. We actually give you 3 different options of how to handle the disclosures. First one is the buyer is conditioned, the buyer's offer is conditioned upon receiving the seller's vacant land disclosure addendum. And it is 3 business days. We don't give you an option. It's 3 business days. And the buyer does not waive the right of revocation. They can change it. We have another one where they want the seller's land disclosure, but they waive revocation. And then the other one, the third one, is waives the right to the vacant land disclosure addendum and all rights from that. The third one I would probably use in the case of a subdivision lot, 0.12 acre you probably wouldn't do. But in anything else, I would probably use the first or second option on that. So we have that now. On the vacant land disclosure, we've done a couple of things. We've changed the protocol to mirror the property disclosures delivery and revocation verbiage. So we've added that to the advisory. It's not statute, but it is something that people are wanting. So the form is there for use. I use it in my practice just because I think it's smart. But again, that's one of your managing broker items. For that. We did some changes, added some things that we have found. For instance, there's a lot of things about timber rights and contracts. There's conservation easements and agreements we've added in there. We've clarified that it's all tanks. There was a lot of confusion on that one because sometimes in farm property you may have a diesel fuel tank, you may have an oil fuel if it's got a lot of farm equipment, chemicals, septic tanks, any of those. are all now kind of listed on the property. Clarifying that the wells serving the property and also where their location on the property. You may or may not know where the location is, but you know that there is something there. Another item we add was man-made ponds or bodies of water. And if that was done in permit, that's very important in some areas to that. And then we kind of softened the verbiage that we had on the last line, other conditions, defects, future problem, material factor, issues of its immediate vicinity affecting the buyer's use and or enjoyment of the property. We've added those words into it.
Did the Forms Committee consider what is meant by immediate vicinity? I'm guessing that everyone may have a different idea of what immediate vicinity means. Was that taken into consideration, or just?
Well, I'm going to go through this. I don't remember the word vicinity coming up in the conversation. I know we wanted to make it a little softer. This is a catch-all like the property disclosure, and we had a nice discussion about we didn't want to have value, which is one of the catch-alls in the property disclosure, which we don't care for. I don't care for it. Even though I'm on the Forms Committee, I'm not really loving the vicinity line at all. And I've been discussing that because that is a concern. What does that mean? We had a case here with Bullseye Glass. It's just in our neighborhood where this carcinogens were coming out, or these chemicals were coming out. There's this big concern, and people are saying, do I need to disclose that on the property disclosure? And the legal was, no, you're only talking about in the property disclosure your property. The Bullseye Glass could be next door. It wouldn't be a requirement of the seller to disclose that because it's right here.
This language seems to broaden.
It broadens.
What beyond the parcel in question, which, I mean, as a buyer, I would certainly want to know.
I'd want to know, but if I was a seller, I would probably be cautious about this. And as an agent, I would point this out, that line, definitely point it out to the seller and see that what they want, how do they want to phrase that, and really be thinking about that one, because that is I think that's probably going to be a discussion we're going to have this year since I brought it up. Mm-hmm. But yes, just be careful of that one. Mm-hmm. Oh, one other thing, can I say one more thing on this? Mm-hmm. If let's say your seller says, I'm not filling that stupid thing out. Okay, I bet you have a seller like that. Fine, but I would highly recommend, just as a practice tip, give it to them anyway and just say, look through this. Just as you don't have to fill it out. If you don't want to fill it out, there's no state statute, but look through this and see if there's something on here that you may need to disclose, just maybe on an addendum as opposed to filling the whole thing out. And this is what Maria already said. The revocation period now mirrors the property disclosure.
Mm-hmm. Okay.
On the condo sale agreement, one of the things we've added is the name, a line that says name of the management company, because we're finding that a lot of they have management companies that do that. Just a little side note, we are hearing about, and I've actually hit this, there are some pretty hefty costs in sometimes getting this information from that management company. Upwards to $495, I'm hearing. So we are going to have a discussion in Forms Committee this year about a line that we may be adding to who pays for that. So just so that you guys know that we heard you, that it's there.
It's definitely something the seller is going to have to do, right? I mean, it's one of those things, it seems, that I get it for you, Steve, you're buying my condo, falls through, I have the docs to provide to buy, then you pay for it. I have the docs to provide to the next potential buyer. But everything's negotiable, of course.
Absolutely. Okay.
Yep.
Okay. Here, this page right here is off the new construction sale agreement. Everything else is the same as we've already talked about that was on the residential, but this is an important piece. The full mediation arbitration section is exactly the same as it is with all of the other sale agreements. But there's Oregon law that's specific to new construction, and I'm really liking the fact that this was added. So Oregon law contains important requirements and homeowners must follow before filing for arbitration or court action, excluding small claims court, against any contractor, subcontractor, or supplier of materials or equipment for construction defects. Failure to follow those procedures or meet those deadlines will affect a homeowner's right to commence an action. If contemplating a claim after closing of this transaction, buyer should contact an attorney for information on the procedures and deadlines under Oregon law. This is a really nice change because if they were sitting there planning on filing, like in the mediation section, no, there's a way they have to provide notice. There's an amount of days that they have to do it in. There's all these things, and if you don't hit all these buttons, then you have to start over and you may lose the opportunity. So I think putting this verbiage in there was a great addition to the mediation and arbitration section.
So is that, it's referencing CCB docs, right? Documents?
Correct.
That they should, okay. We always want to make things easier for people. I don't know, maybe that's a packet we could post, whether it's on OREF website or OAR's website, that they could, I just like leaving people seeing it but not understanding exactly what this means.
That's true.
It's
now,
important.
It is important, and most builders are good about getting the lien notices, which we're really talking in here, and they're talking about the Home Buyers Protection Act information, and it has some of that verbiage in there, but sometimes the developer may buy the property, he has somebody build it for him, and then he's selling it, and it's a brand new piece of property. He says, I'm not the builder, I'm not giving you that information. So having some language in here at the minimum is there. It's helpful.
On the buyer's repair addendum, one of the things that we've added this time is that the seller will provide all receipts for labor and materials with proof of payment, unless it's being paid out of escrow. The key here is to really keep the receipts and make sure that your seller knows that. They may have the plumber come over and it's a minor fix, and the plumber says, give me $100 cash and I'll call it good. Well, definitely get a receipt for that and keep it, because you don't want the plumber coming back going, wait a minute, they never gave me the $100. It is very important that you keep those receipts and turn them over to the buyer as it goes to closing.
Really, that's really good. Okay, Townhome Plan Community Homeowners Association addendum. There's just a small change here. Again, we're hoping to change the name, where it has the name of the management company, if any. So that just mirrors what's on the condo sale agreement.
On the Woodstove addendum, we've just, actually, I don't think it's really a change. We're just highlighting it because we're getting feedback. Buyer should verify with the lender that the buyer can accept this responsibility of the buyer removing the uncertified wood stove. What's happening is that we're getting up, 1 or 2 days from closing. The buyer and the seller have agreed that the buyer is going to take it out, and it shows up on the appraisal, and the lender's going, no, it's got to come out of there. And, we've got 48 hours to scramble, get somebody to get it properly taken out and all of that. This is another one of those where, shockingly, talk to the lender beforehand and find out what it is that they think that the underwriter is going to want, because you may have an agreement between the buyer and the seller, but the lender is going to say differently.
Yeah, we had one where we had 3 here in Southeast Portland, so it's not even that many. We got 3 in just this past year where the underwriter said no. It's not 100%. There's others that'll go right through, but why play that game?
And one other thing that's come up in the classes that I've taught is, remember, as a listing agent, you have the ability to talk to the lender about those things. So if you really, as a listing agent, want to know, call the lender and talk to them.
Good point. Buyer service agreement, it used to be under E for exclusive. Now it's under B for buyer. So.
What a concept. Same thing with the seller fee agreement. It's now under S. And we also changed it so that it says that it's under it's between the seller and the principal broker rather than the agent.
Sometimes, okay, where does this? The screen rolls and who ends up on it? Thank you a lot, Marie. Okay, agreement to occupy after closing had a major rewrite. Most of the terms are the same, but it was convoluted. It had been a document that had been added and onto in different sections, and good idea here, and some of them were almost conflicting. So some people Phil and a gentleman on the Forms Committee spent a lot of time working on this and putting this together. So they did some great work. But I would say read through this. We use this a lot, so read through this. I'm going to go through the major points here, but I'd read through the whole thing. I definitely would do that. First one here, buyer agrees to verify with buyer's lender, if applicable, that the agreed upon term provided herein is permitted by its underwriting department. Another case of this, by Oregon statute, this is a 90-day period, but if a loan is involved, if it's going to be an owner-occupied property, the loan requirements may require them to get in certainly by 60 days. I don't know of anybody that goes 90. But some lenders, we've had in this office 45 days, can't be more than 45. We've had others that say no more than 30. So again, just like Marie was saying, if you're the seller's agent and something is coming up here and there's just saying, hey, the buyer's saying you can stay here for 60 days after, and we're not going to charge a dime. And they say, well, have you asked about the lender? Is that okay with the lender or not? Make sure you do that because, again, that's one that comes 3 days before closing. I'm not going to cover a lot on the rent or late fees, but just take note that it's there. What I'm seeing most of the case is that if there are any rents due, they're all paid at closing. So the seller isn't paying the buyer monthly or anything like that, but the verbiage is in there. Okay, this section and the next section, which we will get to in a minute, are the ones I would really cover with my clients, okay, and make sure that it's clear here. I'm going to skip down as first. Oh, no, back. Well, I'll just read it. Sellers shall comply with all applicable laws, ordinances, regulations, public, private covenants, easements, and permit uses affecting the property, not engage in any unlawful, improper, offensive activities, including the manufacture, distribution, sale, or use of any federally controlled substance in or about the property, or permit or cause a nuisance or environmental hazard condition therein. Now, this is keep the property, including the interior and exterior of all structures, the grounds, trees, shrubbery, and all landscaping in a clean, neat, safe, and orderly appearance and condition consistent with its appearance and condition now at the time of closing. Which buyer shall have the right of inspection to confirm prior to closing and not store any things that are going to blow up. Okay, so this is, okay, in the sale agreement, as we all know, the home at closing is supposed to be in the same condition it was at the time of writing the offer. This is a different agreement, and this situation is talking about something different. If you're going to go out and rent a car, you're going to walk around with somebody with a clipboard and say, okay, there's a dent here, and there's a scratch here, and the windshield's missing, or whatever the case may be. Or if you're going through a house and you're renting a house, at the time you're renting a house, you're going to go through and say, okay, there's a stain on the carpet here, stuff like that. That creates a base so that at the end of the rental period, you can go back through again and say, okay, well, that was already there. That was fine. That's fine. That's fine. That's fine. And so it helps both parties. So that's what they're doing in this situation on this clause, is to create that base if the buyer wants it, to do it. Now, concern some people have had is this feels like a final walkthrough and the buyer can sit there and get out based upon it. Things happen, I suppose that could be, but that's not the case, and it's not what the clause is talking about here. This is talking specifically about the occupancy after closing section. So just take note of that on the in that seller's obligation section.
So Steve, am I reading this incorrectly? I mean, in the last sentence there in parentheses, which buyer shall have the right of inspection to confirm prior to closing. What
Correct.
about prior to possession? If they're in this rent back.
Well, okay, the seller's in the property. It gets a little confused,
Yeah.
but the seller's in the property, so I suppose it could have it after it's already closed. Maybe that's something that might be looked at, but right now they're saying, right now I want to look at it before you even have the property, and doing it like the day
Totally
before, something like that. Yeah.
But what if they rent back for 30, 60 days? Wouldn't your buyer want to make sure the property looks the same as it did at closing when they take possession?
Oh, yes.
Does that make sense?
Yes, and they do. Later on, it does say that. That's a really good question, Jenny. When they're talking about the final walkthrough, especially if there's any a security deposit, and we were going to be talking about that in just a little bit here.
Jumping the gun.
No. See, she's inquisitive. That's good. Okay. This is the section in particular. Now, remember, this is a whole different animal than a landlord-tenant situation. They specifically say this is not a landlord-tenant situation, and so the responsibilities are different than any landlord-tenant situation. So really, this is a section you want to do. So maintenance, repair, replacement responsibilities of parties. The seller's responsibilities. In addition to seller's obligations at Section 5, which we just talked about, seller shall, at seller's sole expense, keep and maintain all heating, cooling, electrical, water, plumbing, and irrigation systems, including wells and septic, if applicable, and all appliances in good working order, and perform any repairs on the property necessitated by the negligent, reckless, or willful misconduct of seller or seller's guests, invitees, or pets. So the second one's obvious. They're moving out and they rip up the hardwood floors. Okay, that was negligent or reckless, whatever the case may be. That would be the seller's responsibility, who is now the tenant-like person. as responsibility. Or let's say the sink ends up starting to drip. The faucet starts to drip. That would be the seller's responsibility to maintain it. Okay, so seller maintains. That's probably in a nutshell. Buyer's responsibility. In the event that any of the systems or appliances in the property fail and cannot, in the opinion of a qualified inspector, vendor, or other expert selected by buyer, who has inspected the same, by repairing so as to continue operating in a safe, efficient, and cost-effective manner for the remainder of the term, it shall be promptly replaced by buyer at buyer's sole cost. So that we're back to, it's the buyer's home. It's their place. If it fails 3 days after it closes, well, maybe their inspection wasn't particularly good at that particular point.
Or things happen.
So if it's a case of it has to be replaced, that is the buyer's responsibility. It's their home, it's their responsibility.
Okay, what if the appliance is gone kaput due to the seller's actions?
Well, that's a good question. If it was by negligent or reckless, like they stuck Drano in their dishwasher and destroyed the whole thing, that would be on them. But just in the normal wear and tear, something happens, a tree falls on the house, something like that. And my personal take is, if you're going to do an occupancy after closing, a home warranty is a really good thing to have in place. Mm-hmm. And this just talks about that everybody's going to be complying, so we don't need to cover on that. Do you want me to continue talking?
Keep going.
Ah, jeez. Okay, insurance. This has been here all along, but there's been a change. So buyer shall secure a policy of casualty insurance in the property for its full insurable value. Makes sense. And seller shall secure a policy of liability insurance listing buyer as an additional insured in an amount of not less than $1 million. It used to have a line and 500, but in cases of liability, really, if you're going to have a liability insurance, you better have a $1 million policy. Now, I know what's happening with sellers contacting their insurance agent, and the insurance agent going, oh, you don't need to change your insurance. Everything's fine. If something happened in those few days, you're covered. Well, back to insurance companies, they're in the business of not paying out funds. So I'm just trying to figure out why, okay, you have an owner-occupied insurance policy. You haven't been there in that property you don't even own the property anymore. A month later, something happens and you apply and want the insurance company to cover it. I would be really concerned that no, they'd say no, that your policy doesn't even apply. It could, but I wouldn't want to take that risk. So just as a tip, I would say if the insurance agent says that to the seller, have the seller send this page to the insurance agent, say, I want to comply with the terms of the contract just so I'm completely covered. But that's your call on that. And it also says that each party agrees that there's a situation and that real estate agents are not experts on these issues. The next section, seller's failure to vacate by end of term. It always is a concern, or it's often a concern with buyers. What happens if they don't leave? Well, okay, now remember we're in this sort of a strange little place with an occupancy after closing. So if seller remains in possession of the property beyond the term provided herein, buyer may deliver manually or electronically to seller a written notice to vacate within 24 hours pursuant to ORS 91. If seller has not fully vacated the property following delivery or transmission to said 24 hours, buyer may thereafter file for eviction pursuant to ORS 105. Okay, so ORS 91 is directly related to this little occupancy after closing in the term of a sale. So you can say 24-hour, get out. Okay. That's not landlord-tenant law. You can't do that, but that's what that one is. But if they stay beyond that 24-hour notice, it basically falls into the FED eviction of any landlord-tenant situation, which is ORS 105. But at least your clients can take a look at that and do that. I had actually do that on my own house one time. It's not very fun. But whatever the case may be, that's why there's two different ORSs there. One is for this and the other is for basically tenant landlord. We added one more. So if buyer shall be entitled to recover from seller in the case where they're after, if the sellers have not behaved well. So we had the liquidated damage sum. We had an amount equal to 2 months rent due under this agreement or twice the actual damages sustained by buyer. And then the third one was added, an amount equal to the daily principal, interest, taxes, and insurance accruing under buyer's notes and trustees for each day following the date that buyer is entitled to possession of the property. My personal take is that's a little skinny, but again, that's up to the parties to decide. But I'd also talk to your managing principal broker and see maybe they have an opinion on which one might be the best one to pick there. Now Marie gets to talk now.
No yellow on this.
No yellow on this one. Nope.
Nope, keep going.
We're going to talk about the professional inspection addendum. One of the things that happens is during the Forms Committee is that we edit these things live on screen, and every once in a while, oops, something gets cut. And this is what happened in the professional inspection addendum. The line, buyer understands the buyer is responsible for the restoration of the property following any inspections, tests, or tests performed by the buyer or buyer's behalf. That somehow got cut out of last year's version. We caught it, and it's back into this one. So it's really pretty simple that it's just added back in. It shouldn't have ever been gone. And then on investment property, really the key on this one is that it is truly listed for 1 to 4 family dwellings or plexes. You may be able, I did one last year, there was a 6-plex that you probably could scroll it there, but it's really made for a non-commercial building. We've added wording that says when the documents should be done. So it says that by 5 p.m. of the final day of the document review period at section 8 below, and then that all documents and information may be readily available. There may be a one, for instance, an ecological or engineering report, they just never have had it, and that's fine. It just needs to be identified that that's going to be happening. One on the due diligence items that we did, we've now put them in kind of the order that's really important. So it does start from most important going down. So current rent roll, delinquency reports, all the way down to capital expenditures in the last 3 years. You may or may have it. On the seller to provide the additional documents, there was a confusion about, surprisingly, about what a Schedule E was. So we actually said Schedule E's or Form 1040 or comparable business schedule, because that's been important for buyers to understand what is actually happening with it. One of the things that was kind of humorous is what is an inspection report? So I know, I thought, okay. So we've now added the words fire inspection, building inspector, pest and dry rot, whole house. We've added those wordings in there. That's what we were thinking of. And I think that's it. We did a few just stylization changes, but it pretty much remains basically the same as what we had. And the next one is that, again, septic and on-site sewage is now under S instead of O for that one. And one of the questions that has come up a lot is, what does the word promptly mean? Promptly to a New Yorker is a little different than it is in Hawaii. So we've changed the words now that says that it's within blank business days, 5 if not filled in, after buyer and seller have signed and accepted this agreement, that the party responsible for paying the above selected service shall have it ordered from a licensed service provider, and thereafter, upon receipt, promptly submit the results to the buyer. And then we've added in the buyer shall have X days, 10 if not filled in, after the date the buyer received all documents, so they can go over it. The idea was just to kind of create a consistency through the form that, so many days to do one thing, so many days the other. Because again, promptly has different meanings to different people.
Absolutely. Just one take on this. Just take note that it says there's 10 business days. That's quite a lot longer than we're seeing any of the other forms have, and these deadlines. So take a look at that, because you're thinking you have 5 business days to get the receipts and you have 10 business days. The buyer can have a whole lot of time here. You might want to.
Why'd you make the date longer? Time frame longer?
I'm not quite sure why it says 10. Yeah. My personal take, and when all the classes we've been teaching, everybody says 5 would be a better number, and that may be changed from the feedback. But just be aware of it when you're filling out that form. Maybe a tighter time frame there might be a good idea.
Good note.
Oh.
Yes,
okay.
You get contingent right to purchase.
Yes, the love of my life. Okay, first off, there's only been one change here, and it's in section 2. The whole format, alternative 1 and alternative 2 are exactly the same. We'll be going through that. That's all been the same, but we changed it around, hopefully to make it clearer. Okay, so I'm just going to start with the one that's really easy here, and I thought it was a great change. Status of listing of buyer's property. Buyer's property is currently listed for sale with a licensed real estate agent where said property is located, or buyer's property will be listed for sale with a licensed real estate agent where said property is located within 3 business days after seller has signed and accepted the sales agreement. I'm really liking that. One, it doesn't say FSBO. We have had that question in the past. No. I suppose you could, but no. And the other thing, so it's just nice. I think that's a really good case. Now, one of the big problems people were having with the confusion on this form, on the contingent form, was the definition of what alternative 1, which is the one that everybody pretty much thinks about, a contingent right to purchase, where the buyer gets an accepted offer on their property, and now they're notifying the seller, but it's still subject to the successful close of their house. That's alternative 1 in a nutshell. Alternative 2 is the buyer wanted to use the funds from their home, but it didn't work out, so they're going to have to liquidate some stocks, but they still want the home, and so they have that option, and they can choose alternative 2. All of that's all the same, but the definitions are on this form, so some agents were feeling they had to check alternative 1 or alternative 2 at the time of writing the offer. No, that's not the case. So Phil came up with this idea. First off, I was going, but I'm liking it. But it's going to create a requirement for you when you're the agent of the buyer and the seller. So what it's saying is acknowledgement of the related forms and additional terms. The notice to seller and notice to buyer contains certain additional terms under which this transaction will continue. Those new terms are set forth in alternative 1 and alternative 2 in both notices. They're exactly the same. By their signatures below, buyer and seller acknowledge that they have reviewed and understand them. If not fully understood, the parties should first obtain clarification through their respective agents. Okay, so when you're working with a buyer and you're working with a seller, and it's great because, and Jeff started this, I think he was the trendsetter, all the contingent forms are right next to each other. So it's the contingency addendum, notice to buyer, contingency addendum, notice to seller. They're all together. Highly recommend you print all of them out if you're going to use this form. So if you're writing it, you're going to have to show them what those terms are. So just as a practice, always print those out. The other thing is you have to use those notices. You can't just put your notice on a blank addendum. You have to use those notices because there's critical information that's required. So hopefully that will clear up that you don't pick alternative 1 or alternative 2. We also fixed this. This is a notice, and so I made it much clearer that it's a notice and it's not an addendum, so we changed it. This is the one, of course, where the contingent right to purchase notice to buyer. So this is where a seller has an offer they want to accept or have accepted subject to being placed in first position, and they're given the notice to the buyer, okay, you either pick something or go away. And so then here's our alternative 1, alternative 2. I'm not going to go through it because we didn't change it. We highlighted it so you could refresh yourself on it, but that's all the same language. Or if they can't, then they can terminate. So, and we run into those cases where the buyer gets a notice from the seller. So they actually had some mutual agreement on a property, but they hadn't told the seller yet. So this is the case of how they're going to be picking those.
One of the items that's been kind of confusing, and Jen, if you can scroll there, when the seller is notifying the buyer of it, they're filling out only the section that's above the black line. The rest of the section is going to be filled out by the buyer. So the seller is only in that first section, not the second section. There was some confusion that the seller needs to fill out what the buyer's response is. No, it's buyer's response to the seller. So above the black line is the seller. Give it to the buyer responds.
Very nice. I'm going to include that. That's a good eye. Good eye. All right. And so then the buyer will be signed at the end. And if they just don't do anything, it terminates. And then here's the notice to seller, what the buyer would be using. And so there's just a notice that they would check, the buyer would check alternative 1 or alternative 2, and then they sign. And that's just a notice. The seller doesn't even have a place to sign there.
Your favorite.
Gee, look at the time.
We're almost there. FERPTA, the only thing on here is that once, like we talked about, is that the FERPTA, instead of now being under advisory, it's now under FERPTA, the F. So we changed the name so it's easier to find. And that we aligned the advisory and the addendum so that they match what's in the sale agreement. So I'm not going to go through it all again because we don't need to, but it is all like we had in the sale agreement.
Mm-hmm.
So.
Okay.
Any additional?
Well, I was going to go to the addendum and talk about section
ahead.
5, my favorite section.
Yes.
Okay. First, I want everybody to breathe, wherever you are, breathe. This is a big deal, but it's a big deal that happens really, really rarely. And it'd be a nice conversation for you to have at your companies and talk about what you're going to be doing with this. When FERPTA is actually in play, it's pretty straightforward, right? The seller says, yes, I am a foreign person or a foreign entity, and there's all the process, and this gets done. The one caveat of that is check with your escrow company to see if they're actually going to do anything, because some title companies have a very hands-off with FERPTA, so that would be something to do. But the terms are in there. There's going to be the withholding, and they're going to need definitely to get in contact with their accountant and get the correct forms and make sure that we had one in our office and the person didn't have to wait till filing in April. This withholding was funneled down to a much smaller amount that was actually put there. So there's some things that can potentially happen. They change laws all the time, so I'm not going to say that will happen, but it was much easier with having an accountant who knew what the heck they were doing on it. The issue here is if the seller is saying, I am not a foreign person, all right, and that's most of the time, right? So I'm going to read this. If seller declares that seller is not a foreign person, this highlighting right here is not there on the form. I just did it because I wanted to point it out. Seller shall, upon request, sign a certificate of non-foreign status, which is now the certificate, which shall include disclosure of seller's taxpayer ID number, social security number, or employer ID number, collectively non-public personal information, or NPI. The original certificate shall thereafter be held by escrow serving as a qualified substitute as defined by FERPTA, or alternatively, if escrow is unable or are unwilling to serve, buyer shall hold the original certificate in such capacity. In such event, buyer covenants and agrees not to disclose seller's non-public information to any third parties unless required to do so by subpoena or court order. In such case, buyer agrees to retain the certificate until the end of the 5th taxable year following the taxable year in which this transaction is closed. If for any reason seller fails or refuses to sign the complete and accurate certificate at closing, buyer may terminate this transaction and obtain a refund of all deposits paid to escrow. Provided, however, acceptance of said refund shall not constitute a waiver of any other remedies available to buyer under the sale agreement. All right. So this is that one. We spent hours talking about this, and basically, I guess the theme was everybody thinks FERPTA sucks. Okay, was that subtle?
That's mild.
And we don't like it, and we were trying to figure out some way to make the federal law better or nicer or gentler. Well, we couldn't. It is what it is. And as hard as we tried for hours and hours, we couldn't, which we could have saved a lot of time. We could have probably thought of that earlier, but we were really trying. So a couple of things here. That certificate of non-foreign status. This is going to be this situation where it could be problematic is going to be a really small little piece. Okay, if they're really not a foreign person, nothing's going to be happening. If they are a foreign person and they say they are not, either because they're being nefarious and trying to get away with something, or they didn't know, most of the time the documents that escrow is going to be requesting during the course of this closing, they're going to discover something's up. And if they discover something, they'll be notifying the parties, and they're going to be doing that. So that would be the case. So, but the concern is, what if it gets past, they're actually a foreign person, it doesn't get discovered at escrow, and then down the road, IRS discovers, wait a minute, money should have been withheld. And of course, with FERPTA, let's say the seller moves to Tierra del Fuego, and there's no extradition with Tierra del Fuego, so they're going to. So, where the IRS is going, well, we know where the buyer lives, and so the whole FERPTA thing is now the buyer is going to be put on the line for that. Let's say it was $1 million sale, so at 15%, that'd be $150,000 worth of withholding. You can imagine this would make a buyer very unhappy. So in this case, the only way a buyer can 100% protect themselves from this, even if they say on their listing, I'm not a foreign person, they say at escrow, I'm not a foreign person, IRS doesn't care about that. The only thing they care about, if they have a certificate of non-foreign status, that certificate, then the buyer is, in quotes, safe. All right. So just some people have been getting really concerned, and I'm spending a lot of time on it, which makes it feel like there's a whole lot of weight. But again, just think about how far down the road it has to be in order for that to happen. But it is a concern. So in this case, and also check with your escrow, they probably won't want to be a qualified substitute, and so it's going to be the buyer withholding this or holding that for 5 taxable years. So some people are saying, hey boy, I need to have one of these on every sale. Again, talk to your managing principal broker. I think there's a risk to the buyer of, if they're requesting this to a buyer, to a seller who is not foreign, and they see this and they actually read it, they're going to go, I'm not giving my social security number out. I'm risk averse to giving out my social security number. This buyer can, I'm not going to accept this. They're going to have to change their mind, or they can go buy it in somebody else's home. But whatever the case may be, I highly, highly encourage that with this out there, and Marie was talking about a company that's wanting the advisory to go in every one of their sales. So this may start showing up more since we've been talking about it some more. So here's my scare. Non-foreign person, your seller says they're a non-foreign, the seller is a non-foreign person. This is put in front of them, and they're going, oh, this is FERPTA, I'm not foreign, I'll sign this. And they sign it just thinking it doesn't relate to them because they're not a foreign person. And then they get the request for their social security number, and they didn't know that that's what they had agreed to do. So when you see this, just make sure, if you see this popping by on one of your listings and you see this in here, really have them cover number 5. That's the most important piece you can be putting in there.
And your 2 good guides also will be your escrow officer, knowing what's going on there, and then also your CPA. That there may be you may have to have a discussion with your accountant on what it also means.
I've had 2 discussions, excellent points, 2 discussions recently about, okay, my person's from Brazil, they're moving back, and there was another one, they weren't both from Brazil, but both cases, they said, does FERPTA apply? I don't know. Do they have dual citizenship? Do they comply with, are they foreign based upon FERPTA's definition of foreign? So again, if the flag is coming up, be sure and get that covered on that. And again, talk to your escrow person what they're doing with FERPTA. Another concern we were having here was somebody says, well, we're going to be that there's a potential that we're going to be profiling people with this. Does somebody have an accent? Do they have a look different, or whatever the case may be? No. That's not it at all. I think it could be probably the one that's going to sneak by would be one you would be surprised about anyway. But no, this is not profiling, and please do not be doing anything like that. I would be very hesitant about if you had somebody with a certain last name, you wanted to have this in the file, but if they didn't have that last name, you wouldn't do it. I wouldn't want to have that sort of stuff in my file. But again, talk to your managing principal broker.
Okay. Lease option advisory, the only thing we did is it was an advisory. Now it's a lease option advisory, so now it's under the L's on the alphabet because that's where you're going to be looking for it. And we also, on this one, we did put in the buyer and seller acknowledgments on this advisory. We felt it was necessary to make sure that everybody knew what was going on.
And that's kept consistent with our other advisories.
Exactly, it is. The next item is actually on the Oregon disclosure pamphlet. There was a confusion, and so now it says, if applicable, see disclosed limited agency agreement for identification of disclosed limited agent on that one. And by the way, in the real version, it does not have real estate crossed out on the next line there. That's
yeah.
This was our edit version, so it's but you can see it. But that wording was changed on there.
And I like the change because, as you know, this is for the public to understand agency, and through this are talking about the disclosed limited agency, and then they says principal broker. Well, their agent may have principal broker written on their business cards. So are they a disclosed limited agent? So hopefully, if somebody reads through this, and I think the percentage of people that actually read this could be in the tenths of the digits, but if they do, this will be really clarify that they have to check the other document. And of course, most of the time, they're not going to know what the disclosed limited agents agreement is at that time. They wouldn't be getting it at first substantive contact, but it's in there. So I like the change, and I think we're done with that now. It was a mess a couple of years ago.
And then finally, the lead-based paint addendum itself, we aligned the sale agreement and the time frames so that lead-based paint and the sale agreements are now the same.
Jenny, can we scroll up just a little bit? So
I'm sorry.
That's what you've been doing, an awesome job.
Thank you.
She's a professional.
Super good multitasker. Okay, I apologize.
No. So, okay, so just like she said. Now, I believe, it's interesting, Marie and I have taught this solo, and most of the time this takes an hour and 50 minutes, an hour and 55 minutes to do by ourselves and with questions and things like that. But when we found out that this was going to be a little bit shorter, I think we all talked a little faster, and you got all the information, so we have some time.
We have a couple questions, and they weren't specific, and since because I clicked back onto the questions, I'm not exactly sure. I guess they're talking about the FERPTA addendum. The question is, so are you suggesting we use this addendum for every transaction?
The answer is talk to your managing principal broker and how they want to handle it.
How they want to handle it. I'll just say what in our office, I just taught a class here yesterday for my branch, and I said, I don't recommend it, but talk to your buyer. It's a buyer's decision where they want to put it, but I would not put this as I think it's, especially in a competitive market where it's a seller's market, I would think this would put your seller at a definite advantage, but it's also the small percentage where the buyer's at risk. So if you have an incredibly risk-adverse buyer, then maybe you include it, but I wouldn't put it in every sale agreement, no. But check with your managing principal broker.
Yeah. And I'm not sure which this might be the notice. What if the buyer, I think they might mean seller, wants to sell as a FSBO and thinks they currently have a buyer lined up? I don't know which form.
Oh, I know. They're talking about the contingent right to purchase, and it is buyer. So there's additional provisions section on the contingent right to purchase. If they wanted to write that in, they could. I certainly didn't want to, I don't feel that we wanted to make it an option, hey, you could do this for sale by owner. So we're talking about the real estate agent. But if in a case where that buyer wants to, and it's their decision, right? They're writing the offer.
I'm sorry. Okay, now I know.
So if that buyer wants to say that, no, I'm going to sell it, I have somebody or whatever, fine. If I was a seller, I'd say, okay, well, if you have somebody that you think you have, I'll give you 3 days. But if you don't, their buyer needs to get here soon. If not, I want this listed with a real estate agent. That would be my response.
Timeline, prove it.
Yeah.
Seems that back to, I think, the FERPTA. Okay. Suggestion on the contingent right to purchase. Instead of listed, shouldn't it say active on the market? Some may just choose to sit in pre-listing status.
That's an interesting take with a whole new coming soon. Yeah, and that was a new change that hasn't even come out yet. But that's an interesting nuance. I think I like that. That should be something we might discuss in changing that. That's a good point. Maria's writing that down? Yes, and but again, we don't even have the coming soon status yet live, but I like that.
So back to paragraph 5. So for those of you who sent questions, we were going to take them throughout, but we couldn't. What about the sellers that use and grow their own medical marijuana plants? Paragraph 5.
Right. In that case, if they actually do that in additional provisions, I would. And 90% of the time, they want to have it that way, the way that the contract is written. But if you're going to change something, which would be, and it would certainly make sense in that case, I would definitely just change that to make sure that your client is complying with the terms of the contract by altering it in the additional provisions.
If you are working on a commercial property, is there any time when you don't need to use the seller's property disclosure?
On the seller's property disclosure, it states that it's for 1 to 4 units. So if it's a commercial property or a larger one, you do not have to use the seller's property disclosure. It's written in there that it's 1 to 4 units.
Very clear.
Mm-hmm.
No, that doesn't mean you can't. But,
No,
but
in the sixplex that I sold last year, we did ask for it, and we all did it because it just seemed the right thing to do with that particular piece of property.
yeah.
That are not a requirement.
It was not a requirement, but it just was the right thing to do.
Can you talk, you might have done this, can you talk about the septic and well addendum timelines being different than that on inspection negotiation period in the sale agreement? We did.
Oh, okay, come on. No.
What we have is that you have the inspection time period that's in the sale agreement, and I'm going to have you jump in here too. But when you have an addendum, that changes those particular items. So the whole, you've got 10 days for the whole house inspection, but you have 5 days for the well and 5 days for the septic. Those are standalone documents and standalone timelines that are different from the whole house inspection and those timelines that are in there.
Absolutely. Well, that just brings up another point. And since we have a couple of minutes here of this, the situation on, and I know what you're talking also, everything, most of the timelines inspection is certainly based upon when it's signed and agreed to. So that's when that occurs. But there's several addendums: the septic, the well, the HOA addendum, the investment property addendum. All of those addendums start upon when the seller has delivered all the documents that they have available to them to the buyer. So that clock starts ticking. So in order to make it happening from the beginning doesn't make sense, because it's going to be a varied amount of time before they actually have the documents in order to review it. So that's why those are different, those different forms there. And just one point on that, we have an issue, this is a tip more than anything, and I'm sure your managing principal Brooks have all told you this. Memorialize, if you're the listing agent, get all those documents, have your seller get all those documents together, deliver them to the buyer, and then a document that says, okay, we've delivered everything we have, here they are, the seller does not have access to these forms, so the document review period commences now. Make that a very specific, okay, the clock starts ticking right now, in any of those cases with those timelines that aren't tied to the sign and agreed to time.
I'm going to add that we actually had an incident where the buyer had clicked that the buyer's waiver of inspection contingency, and the seller read that as they would not allow any inspections at all, whether that was the well or the septic. And again, the well addendum and the septic addendum are separate from the contingencies that we have in the sale agreement. They are standalone documents, so they don't go in that same timeline, and they also are not waived.
Right.
On vacant land disclosure, why is there not an exclusion for a personal rep of an estate? It's not legally required.
You're the professional on that.
I know it. We just have not. We've actually hadn't been asked that question. There is the ability that the seller doesn't have to provide it, so they don't have to do that. I believe that would kind of fall under that same category, that it's an estate we don't know. I think it depends. I had an estate that I sold that it was the granddaughter, and as we were going through it, she was like, oh yeah, I remember that. I remember this. And we went trekking out there and found the second well. So I think it's up to the individual transaction that you're dealing with.
Where those exclusions are by statute on the property disclosure, this is set up. We really would like you to give it to us, and whatever the case. And so it's a little softer. So, but I'll take a look at that afterwards on that.
Mm-hmm.
Yeah.
All right. The sales agreement under FIRPTA, it says seller shall, upon buyer's request, complete, sign, and deliver to buyer a FIRPTA cert of non-foreign status prior to closing. If they refuse, seller agrees to the withholding. Okay. The question stops. I'm guessing they want to know if that will satisfy the IRS.
We're not accountants. I don't know.
I don't know. We should have a disclaimer at the bottom of your screen. We are not experts in. Sorry. I'm not being flip with your question, that it was truncated, so we weren't quite sure what you were asking. So our apologies.
And I think Steve's answer is good. That's a legal advice I would recommend they didn't answer, even if They really did know, because that's pretty significant consequences if they're wrong. So if the earnest money is due within 3 days, I'm guessing this is promissory notice, how is the contract binding until the earnest money is delivered?
Why don't you take that one, Jenny?
It's exactly the same way as if you had a promissory note. I mean, a promissory note, especially the way you all used to fax them, it's not even a legal document. It's a faxed document. The promise is contained within the contract. The earnest money, it is binding when everyone agrees that the earnest money will be deposited, collected and deposited within 3 days or whatever you agree to. So your consideration is in there. Just because you don't physically have the money in your hand, it's there and it's agreed to, and both parties have made a bilateral promise on that.
I thought that was a Jenny answer.
Buried septic needs to be a separate line item other than buried tanks. The effect of these being together is that the actual hazard tanks are obscured by the presence of the septic tank. I think that's not really a question, but I'm thinking that's
Okay.
I don't know. In your practice, do you see that?
We're going to get copies of the questions here, and some of that was not a question. That was more of maybe a suggestion. So we'll be taking those too and looking at that. We have a very full agenda for January, I have to say. So, but yes, if you put that in, or if the person who wrote that would like to put that and make a recommendation, formal recommendation on what they're thinking in an email to OREF, that would be great too.
So on this interesting, someone says they contacted the IRS. They do not have a certificate of non-foreign status. So I'm assuming by that they mean there was no template that was followed in development of. Was that just how did that certificate, was that Forms Committee advice of Counsel drafting brought to the table kind of thing?
This was advice of Counsel. I thought I found it. I think I found one, but you did your research and you're not, so I'm not disputing that. But we did have one in our branch, and they got all the forms that were needed. If that form is incorrectly identified, then that would need to be corrected. But I believe I did find one. So
yeah, sure, the language must have come from somewhere. So let's do another. I think we're done. Our last question on the agreement to occupy. What if the property is not insurable? Need a checkbox option to allow for other provision. Otherwise, I have to rewrite the agreement practicing law. No, you really don't. That's not practicing law.
Well,
that's just an additional provision.
So their question seems so someone's going to be living in the house, but it's not insurable. So it must not have been insured before.
Yeah, you probably wouldn't have even closed when the title comes. I mean,
yeah, I don't. Okay, I'm guessing that you must have a specific. Whoever wrote this has this actually occurred. That's usually what I see. If something is not insurable, then either seek legal counsel on that, but you could draft something that says this house is not insurable, therefore no money. Whatever liability, you can get liability insurance, but whatever the case may be, I would talk to my insurance agents and find out, okay, this is the situation with this house. What can we do to protect both parties?
Because typically you know that before you close, right? When you're representing buyers, you're insured. You can't close without a binder.
Right.
Right. I mean, so.
Well, if it's a cash transaction, you may or may not, but I'm kind of confused on the question, so.
Yeah,
all right, we're confused on the question.
Okay.
0 for 3 over here.
Last one?
Let's do one last question. I'm guessing this is line 306, 307. The 3 business days is now starting immediately. Not sure which.
Okay, I believe they're talking about the earnest money. Yes, it starts once. Yeah, you just need to read the whole line there. When the sale agreement is signed and accepted by buyer and seller, okay, boom, that happens. The following instruction shall immediately apply. So that's basically day 0. So now you have 3 business days and move on just like you always did. That's not a change.
Okay.
All right. Thank you, everybody.
Yeah, sorry, people. All right, we can't get to all the rest of your questions, but we'll save them and respond. Some of them are formatting type questions that we can get to. Thank you, Steve and Marie. We appreciate your expertise, and I'm sure there'll be plenty more questions just when you've finished the 18 changes for 19.
All right.
All right, have a good day.
Have a great day, everyone.